Welcome back. Some of the previous videos we talked about some of the most common estate planning questions that have come up, but in the last 2 years, one of the most frequent things that we are getting phone calls about is making sure that you have medical powers of attorney in place. With COVID-19 being rampant, we have run into so many issues with people that are desperately looking for that information. So really quick, what are some of the 3 big documents that you need to have in order to make sure that you have proper medical powers in place? First one, a medical power of attorney. This document exists because if you ever become incapacitated and someone needs to make medical decisions on your behalf, you want to make sure that you've appointed an agent who can represent you to a hospital, to a doctor, or anything like that. Now, the next document is called a living will, also known as an advanced physician's directive. And a lot of people get that term mixed up because it sounds like a last will and testament, but it's called a living will. A living will really does one thing only. The major purpose of a living will is to give somebody the authorization to make end-of-life care decisions. In other words, the common terminology is giving somebody the authorization to remove you from life support. Now, that one is really important because frequently people will stay on life support for far too long, and it will raise bills and things that are way unnecessary, especially if you are just being kept alive by a machine, for example. Now, the last document that people frequently ask us about is the document called a DNR, a do not resuscitate. Everybody thinks a living will and a DNR are the same thing. That's actually not true. A DNR is that paper that you see, it's typically printed on orange paper, and they tell you to put it on the side of a refrigerator. A DNR, or do not resuscitate, is different than a living will in this regard. Do not resuscitate is basically telling people, or basically emergency responders, if you find me laying down on my kitchen floor and I am not breathing, then please do not resuscitate me. Now that's different than a living will, because a living will is you've already found me, I'm on machines being kept alive, and now I'm giving someone the authorization to remove me from machines. So that's why a DNR and a living will are different. DNRs are typically for people who are much older and they're at a point or stage in their life where they wouldn't have the same quality of life if you were to find them, and so they're basically asking, don't resuscitate me at this point. For younger folks, you probably don't want a DNR, right? You would just want to have a medical power of attorney and a living will that if you were ever on life support, someone would have that decision to remove you. So those are the 3 big documents in Arizona that you would potentially want to have. There's one other little small one. It's a mental health care power of attorney. That is typically combined with the medical power of attorney in Arizona, but I have seen them separated out. That is something unique to Arizona, where you are giving somebody the authorization to make mental health care decisions for you. That's something good for a lot of people to check. If you already have existing documents, make sure that mental health care proxy is in your documents, or that potentially you have a separate one. Those are the medical documents you need, especially during this time where so many people are being admitted to hospitals unexpectedly with COVID-19. You would want to make sure that you have these documents in place. And I hope you learned something new about medical powers of attorney in Arizona.